The first bill on the calendar for the day is House File 3488. The clerk will report the bill.
House File number 3488, number 1 on the calendar for the day, an act relating to labor, the third engrossment.
I recognize the member from Anoka, the author of the bill, Representative Stevenson.
Thank you, Madam Speaker. This bill relates to the phenomenon of children working as social media influencers. And many of you are probably not familiar with this concept, so let me tell you the story of Samia, as told by the New York Times. Samia was an influencer before she could talk. Her parents, Adam and Latoya Ali, are influencers themselves and began chronicling Samia's impending arrival on YouTube and Instagram in 2014 once Miss Ali learned that she was pregnant. Samia's birth video is on YouTube, and so she's pretty much been born into social media, Mr. Ali said. Samia is now 4 and has 143,000 followers on Instagram and 203,000 subscribers on YouTube. Her feeds are mostly populated with the posts of her posing and playing, but they also feature paid promotions for brands like Crayola, Homestyle Harvest chicken nuggets. This can be big money, members. According to the Washington Post, mom influencing is a billion-dollar industry. Kyle Fisher, the father of 2-year-old identical twins who have more than 2 million followers on Instagram, said a sponsored post on the girl's account could fetch between $10,000 and $20,000. This also has a very dark side. Consider the phenomena of mommy-run accounts. These are social media accounts purportedly for young children, but actually run by their parents. Some of these accounts feature scantily clad pictures of teen and preteen girls. Some of these accounts offer access to even more content behind a paywall. The New York Times recently did a massive investigation into these accounts across multiple platforms. The results are incredibly disturbing. Alyssa had been running her daughter's Instagram account since 2020, when the girl was 11 and too young to have her own. Photos show a bright, bubbly girl modeling evening dresses, high-end workout gear, and dance leotards. She has more than 100,000 followers, some so enthusiastic about her posts that they pay $9.99 a month for more photos. Over the years, Alyssa has fielded all kinds of criticism and knows full well that some people think she's exploiting her daughter. She has gotten used to receiving creepy messages. I think they're all pedophiles, she said of the many online followers obsessed with her daughter and other young girls. Thousands of accounts examined by the New York Times offer disturbing insight into how social media is reshaping childhood, especially for girls, with direct parental encouragement and involvement. Some parents are the driving force behind the sale of photos, exclusive chat sessions, and even the girls' worn leotards and cheer outfits to a mostly unknown followers. The most devoted customers spend thousands of dollars nurturing these underage relationships. One calculation performed by an audience demographics firm found 32 million connections to male followers among 5,000 accounts examined by the Times. Interacting with the men opens the doors to abuse. Some flatter, bully, and blackmail girls and their parents to get racier and racier images. The Times monitored separate exchanges on Telegram, the messaging app, where men openly fantasize about sexually abusing the children they now follow on Instagram and extol the platform for making those images so readily available. Quote, "It's like a candy store." Quote, "God bless Instamoms." In interviews and online comments, parents said that their children enjoyed being on social media or that it was important for a future career, but some expressed misgivings. Kaylin, whose daughter is now 17, said she worried that a childhood spent sporting bikinis online for adult men had scarred her. Quote, "She's written herself off and decided that the only way she's going to have a future is to make a mint on OnlyFans," she said, referring to a website that allows users to sell adult content to subscribers. She has more than that to offer. She warned mothers not to make their children social media influencers. "With the wisdom and knowledge I have now, if I could go back, I definitely wouldn't do it," she said. "I've been stupidly, naively feeding a pack of monsters, and the regret is huge." Account owners who report explicit images or potential predators to Instagram are typically met with silence or indifference, and those who block many abusers have seen their own account's ability to use certain features limited, according to the interviews and documents. In the course of 8 months, the Times made over 50 reports of its own about questionable material and received only one response. Meta, Instagram's parent company, found that 500,000 child Instagram accounts had inappropriate interactions every day, according to an internal study in 2020 that was revealed in legal proceedings. It's a brave new world, members, and it's one that we need to put guardrails on now. This bill does two things. One, it builds out from our existing child labor laws and establishes that children under the age of 14 cannot work as social media influencers. The second thing it does is say for children who are older than that, that they should be guaranteed a portion of the profits. We have to set aside some of the money in a trust account for their benefit when they're older. This is a concept that might sound familiar to you because it's one that's been in place for many decades in some jurisdictions for TV and film child actors to prevent parents and managers from taking advantage of them and stealing all the money. Other states have introduced legislation like this. Illinois has passed it. California has passed it many years ago for film and TV. Members, I think that this is an important bill that we pass today, and I look forward to a good discussion.
The clerk will give the bill its third reading.
Third reading, House Bill number 3488.
Third reading. Discussion to the bill. To the member from Anoka, Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Stevenson, for this discussion. And thank you for referencing that New York Times article. You and I have had a chance to talk about that a few times in committees, and I hope not only every member of this body reads that article, but I hope every parent in Minnesota reads that article, because it is really shocking. And I think I told you my first reaction. We've talked about this bill a couple times in a couple committees. I think I told you my first reaction to this was that it doesn't go far enough in dealing with some of those particular types of instances. And frankly, I think, some of those situations are probably child protection level situations. There's some really disgusting stuff happening with some parents who are really exploiting their kids. And I think if there was a way that we could have a vote on whether some of those specific instances should be prohibited or maybe even more significant sanctions were allowed in those circumstances, I think we'd probably have a unanimous vote. I'm a little worried we might not have a unanimous vote on this particular bill because the devil does get into the details. And so I wanted to explore with you a little bit about, because this is and I appreciate this is a very hard area to draw those kind of legal lines, especially some of the things we would want to do probably are content regulation, and that gets tricky. But I did want to explore a little bit about how the bill does try to draw those lines. And I appreciate there was a lot of good faith work done to try to draw those lines appropriately. And so the first question, if Representative Stevenson would yield.
Representative Stephen will yield. Representative Niska.
Thank you, Madam Speaker. Representative Stevenson, I'm trying to understand exactly how this applies in a situation in which the person creating the content is is either a child. I think there's distinctions between maybe a 14-year-old minor and maybe even a 12-year-old minor. If someone is completely the minor themselves is totally responsible for without like an adult overseeing them. And in particular, a lot of the definitions here are driven by the terms engaged in the work of content creation and then content creator. And in particular, on lines 2.2 and 2.3, it says, content creator does not include a person under the age of 18 who produces their own video content. So what I think, and maybe there's a little bit more clarification that could be done in here, how does this bill regulate, if at all, a 12-year-old who's creating their own content without any adult supervision, if they're able to somehow get, an account somewhere, or a 14-year-old who is solely creating their own content without adult supervision? I think maybe those kids are not regulated at all by the bill, but I'm curious to hear if that's correct or in what ways they might be regulated by the bill.
Representative Stevenson.
Well, thank you, Madam Speaker. Thank you, Representative Niska. And you kind of alluded to one important fact, which is that in the United States, children under the age of 13 are not allowed to have their own platforms. And so when we're talking about children under the age of 13, what we're really focusing on here are those mommy-run accounts or the parent-run accounts that I discussed earlier, where a parent is posting things, managing the account on behalf of their minor child. When you get above that age, then of course, a minor child can have their own account, and so it's different in that respect.
Representative Niska.
Thank you, Madam Speaker, and I appreciate that, Representative Stevenson. And obviously, yes, generally the age of consent, and most platforms are trying to keep kids off who are under 13. I think it's possible, and I think the way I read the bill, maybe there's some more clarification that could be done, but I think the way I read the bill, that wouldn't, and the bill wouldn't do anything to regulate that situation, mostly because there wouldn't be any work of content creation happening with if there was no content creator who is over the age of 18. And I think that's probably good. I think we probably should leave that unregulated, at least as we're trying to deal with the particular problem that you're raising, which again, I agree is a very serious problem. The other thing I wanted to clarify, I just wanted to help and maybe help everyone to understand what the work of content creation means. And the way I understand it, and I'd appreciate if Representative Stevenson could clarify this if he will yield.
Representative Stevenson will yield. Representative Niska.
Thank you, Madam Speaker. Representative Stevenson, the way I understand the work of content creation definition, which really kind of triggers all of the other regulation in the bill, to my understanding, is that it only applies in a situation in which there is a significant portion of the content creator, again, talking about someone who's over 18, their video produced in any 30-day period has 30% of a particular minor's likeness, name, or photograph in that content. And there's also a threshold about how much money or the level of monetization that has to happen. And both of those things have to happen in order for that minor to be considered engaged in the work of content creation, which would trigger the ban for kids under 14, and then also the requirements that they be, a compensation be put into a trust fund. And so I guess my next question would be, am I understanding that general framework correctly?
Representative Stevenson.
Thank you, Madam Speaker. Thank you, Representative Niska. I think you did describe it accurately, yes.
Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Stevenson. And I guess two specific questions about that. The first would be, does that 30-day trigger then result in them being considered engaged in the work of content creation for an entire 12-month period? That's the way I read the language in 2.5 through 2.7.
Are you asking Representative Stevenson to yield?
If Representative Stevenson will yield, thank you.
He will yield. Representative Stevenson.
Thank you, Madam Speaker. Thank you, Representative Niska. I think that if in any point during the 12 months you meet that 30% threshold or the financial threshold, then you're within the scope of the bill. I would agree with that.
Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Stevenson. And then the other question that I was hoping you could enlighten us on with respect to that definition is there's a threshold, an additional requirement that they receive compensation for video content equal to or greater than 1 cent per view. That's on line 2.16. And I just was curious. I think we talked about this some in a committee, and I don't know enough about how platforms monetize content to understand. Can you give us some sort of sense about what type of an account or what level of monetization that refers to sort of in the real world? If Representative Stevenson will yield.
Representative Stevenson will yield. Representative Stevenson.
Thank you, Madam Speaker. Thank you, Representative Niska. I don't have statistics for you. I can't quantify the amount of people who would meet that threshold. That threshold is clearly designed to separate the sort of incidental occurrence of making money from people who are doing it on a more systemic level. So it takes it up a level of threshold. We're trying to not capture every person who ever posted something on the internet, right? So we have both the threshold of frequency and the financial threshold that shows some significance. I hope that's helpful.
Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Stevenson. I was hoping for something a little bit more specific, and maybe that's a topic for some further discussion down the road. I guess the last question I would have, if Representative Stevenson will yield.
He will yield.
Thank you, Madam Speaker. Representative Stevenson, I was just curious, just generally how this would apply. I mean, there's a lot of talk about, in the athletics world, about name, image, and likeness endorsements. Just curious how this might apply to a high school student who has a name, image, and likeness endorsement deal.
Representative Stevenson.
Thank you, Madam Speaker. Thank you, Representative Niska. I think that in general, and without being an expert on name, image, and likeness deals, I think a couple things are important to remember. One, of course, is that as we were just discussing, the prohibition exists for people who are under the age of 14. I don't know how many kids under the age of 14 have name, image, and likeness sponsorship deals. I'm sure that does exist. And beyond that, there's a protection. It's not that you can't engage in content creation for money, it's that the money has to be set aside for your benefit later. So to the extent that name, image, and likeness deals somehow were interpreted to be included in this, I think it would be appropriate to say that the kid should benefit financially and that the money should be set aside. Having said all of that, I think it, to my mind, unlikely that a name, image, and likeness agreement would fall within the scope of this bill, given the definitional discussions that we're having about content creation and what is involved in that.
Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Stevenson, for that conversation. And again, I want to kind of circle back to where I started, which is I agree very much that this is a really serious issue. We've talked a lot in this chamber, especially in the last few days, about protecting kids and prioritizing protection of kids, and there's obviously a real problem. Hopefully it's not a huge number of kids that are being exploited in this way, but there are some kids that are being exploited in this way. And I do salute you for a real good faith effort to try to deal with this. I'm not sure that I think it's probably a little over-inclusive and under-inclusive of the particular problem that we're trying to deal with. And honestly, I've been going back and forth today on whether or not to vote for this bill. I think it's almost there, and I think I think it's a good start, and I do think we should move it forward today. So thank you for the conversation, and like I said, thank you for this work on behalf of kids in Minnesota. Thanks.
I recognize the member from Meeker, Representative Gilman.
Thank you, Madam Speaker. So I'm just going to tell you a little flip side of some positive things with some folks in my district. I've got actually 3 families that I know personally that this is their way of life. One has 5 kids homeschooled, another one, I think they do kind of public school, and then another family is homeschooled family. But they have actually retired their husbands from their big-time jobs and their big-time insurance and all the things that comes with that, solely being online. And their children are a part of this business. So one is a DIY content creator who's gifted and has worked so hard to brand herself, first through photography and then other means, and then just has kind of grown her platform. But I guess, like, when I'm looking at lines, like the records required in 2.28 all the way to, into the 3s, okay, on down. My question is, if the author would yield for a question here. When I'm looking at like on 3.1, the amount of content creation that generated compensation as described in the subdivision 1 during this period, my question is when it talks about the total number of minutes, they have to calculate the total number of minutes the minors in this content, and then compensation that's required. I'm just curious, like, how would they be doing the recording of all this, and how would this be done, and who would govern this? That's my question.
He will
If he would
yield.
yield.
Representative Stevenson.
Thank you, Madam Speaker. Thank you, Representative Gilman. So first of all, it's important to start at the top of subdivision 2, which is the area that you were looking at, starting on line 2.28, which is all video content creators whose content features a minor engaged in the work of content creation shall maintain the following records. So that's important because you were referencing a friend who is having a DYI, channel, right? And if minors aren't involved in that, if they're not featuring their kids on a basis consistent with what we were just talking about with Representative Niska, 30% of the time in a month over a 12-month period, or not making the amount of money, then these record retention things don't apply at all. So if you're doing it and you don't have kids or you're not involving your kids, no impact on you. The records are important for the purposes of establishing the trust and how much money needs to go into the trust to meet the other requirements in there. And that's to make sure that if the kids are working as influencers, that some amount of that money should flow to their benefit. And you asked how that would be enforced or regulated. I don't think you said the word enforced, but that's what I understood your question to be. There's no, for the trust requirements, it's by a private right of action. That is, the child, when they're 18, has a right to that money against their parents if they did not set it aside, if that makes sense.
Representative Gilman.
Thank you so much. So the families that I'm speaking about, their children are an active role. They are an active part of this. And that's my question is, that's why I bring up that question is because, I mean, even if it's them rolling out a rug on a reel or showing the books that they read or they're on vacation, and because their brand has grown so much, I mean, some of them are making over $100,000 a month. This is big time money. They've built their company, their business, they're making $100,000 a month, and their family is a part of the business. And so I appreciate you kind of spelling that out. So my question would be then, is if they are under that, I'm curious how they would have to, monitor all their content and scale it to see if they would be hitting that 30% or not. If in the grand scheme of things, they're already under law, child labor laws, things like that, I mean, that's already happening, and they're compensating their children and their family by affording the life that they have right now through their business. So my question is how would they monitor that to know if they were above that 30% or below here? I just didn't know if there was enough in there to spell that out. If you would.
Representative Gilman, you're asking Representative Stevenson to yield. He will yield. Representative Stevenson.
Well, thank you, Madam Speaker, and thank you, Representative Gilman. And you're absolutely right. It is big time money, right? And it's important to note that for a lot of these content creators, the reason why it's big time money, the reason why they're able to get so much money is people want to see the kids, right? And there's all sorts of stories out there. You can go and look at what that looks like for the kids, how their daily life is impacted. Even setting aside what was talking about in my opening remarks or what Representative Niska and I were talking about, the sexualization. But even just in the work of content creation, it is work, multiple takes of doing the same thing, whole days setting up an idea. And there's really compelling narratives from people who have lived that life about what that was like in childhood, because it is work. No one pays you $100,000 a month to do just, post a picture here or there. It's creating these whole videos and everything else. And it's my belief that if a child is engaged in that work, that some of that money is theirs and shouldn't just be taken away by the parents and the managers. So your question is, what is that going to look like for the parent to assess whether or not it's 30% over a month-long period? I don't think that's an unreasonable thing for them to have to look at that, to look through the content they're posting and see, is the child on the screen more than 30% of the time when you look at the aggregate of what they produce? And frankly, if someone's making $100,000 a month or even $10,000 a month, doing some work to document that and to comply with this law designed to protect the health and safety and well-being of children is not too much to ask, I don't believe.
Representative Gilman.
Thank you so much, and thank you for that, that answer. I appreciate it. That answers all my questions. Thanks.
I recognize the member from Wright, Representative McDonald.
Madam Speaker, Representative Stevenson, Stevenson, yes, we've had that debate in committee when you brought this to the floor, to the committee. And on the surface, I was against it, wasn't sure I could support it, but when you cited the New York Times article, it alerted us to some of the challenges and some of the bad things that are happening. I also looked up many other articles from LA Times as well, indicating several things that parents are taking advantage of, in the filth and the bad actors, the bad behaviors, the immorality of families, and how they could do that to their children. Shows a lack of character in what's happening in our society, where morality is thrown out the window in the sake of the almighty buck and at the sacrifice of children, innocent children. So that, getting at the root of that is certainly we must do as lawmakers. But like Representative Niska, I think the bill is problematic at best. Personally, I think we as lawmakers need to be careful as we get into the homes of our family members and tell parents and children what they cannot do in making content and how much they should be distributing to their children and putting in a trust, when I'm aware of many representatives who have cases in their district, such as I do. And one particular influencer has many followers, 154,000 followers, and oftentimes she is compensated, or this person is compensated by some goods that this person promotes. It's not always monetary. So in your bill, in looking through it and reading it for the last month or so, how do you compensate for a content influencer who's receiving products that he or she is promoting with the use of their children as well? How is that calculated in the language? And I believe it's not. And I'm just curious as your response to that. So if Representative Stevenson would yield for that question.
He will yield. Representative Stevenson.
Thank you, Madam Speaker. Thank you, Representative McDonald. So when we look at the trust required account, or section of the bill, which starts on line 3.13, paragraph A1, starts to talk about if it's one minor, the amount that has to be set aside for the child relates to the gross earnings on any video segment. And so if you had non-cash gifts, I think we would be talking about the value of those. I shouldn't say gifts. Non-cash earnings, I think we'd be talking about the cash value of those earnings.
Representative McDonald.
Madam Speaker, well, therein lies the difficulties of your bill, because oftentimes a person who is receiving no cash but products by advertising those, is it wholesale or resale? So there's many problems in that section of the bill. So then what happens? The content influencer, the family member, has to itemize and put into a trust the resale, the wholesale value of those products that they're using as a family to live on, right? I don't know how one would justify or account for such a thing. And matter of fact, I don't think the law in your bill, if this should become law, would even you could even do that. I don't think that it puts in there any stipulation or protects, if that's your intent, to protect families from bad actors, if you will. Because certainly you don't want to get involved in the families, such as Representative Gilman mentioned. 3 of her constituents have their income to sustain the household. So in that respect, Representative Stevenson, and I just speak because I know that the products are given or received, not necessarily monetarily. So those would not be included then in your bill if it should become law. If you would yield for that question, if I made any sense to you.
He will yield. Representative Stevenson.
Madam Speaker, Representative McDonald, I'm sorry, I didn't follow the question there, but I think, so I think what I understand your question to be is about, again, those non-cash things that someone might receive in compensation for their influencing, and those could range from being minor, they could be very, very valuable things. And again, you know, my view, the view of the people who support this bill is that if a child is doing this work, if it has that impact on their lives, that a portion of that value should go to their benefit, be set aside for them. And I'm not sure that that's an answer to your question. I'm not. If you wanted to restate it, I would be willing to try again.
Representative McDonald.
Madam Speaker, no, I'll just make this point because it was made to me by my friend who I work out with and who has a content influencer or creates content and occasionally uses her children. I don't know if it's 30% or not. She's concerned that she'll have to keep track of that, of course, and the period in time in which that minor appears in the footage in the first place. But she had grave concerns of, so a family could receive X amount of dollars worth of products, and not cash products. And then that person would have to itemize the products that they receive, and you calculate wholesale or resale, and then that, whatever the value is, that would have to be put in this trust according to your bill. I think there's very problematic in that scenario, and that's a real scenario brought to me by a good friend and constituent in my community. So that's all I have for now.
I recognize the member from Anoka, Representative Scott.
Thank you, Madam Speaker, and thank you for a really good discussion here today, members. Representative Stevenson, I appreciate you trying to take this on. You and I have had a couple of conversations about just the complexity of getting at the problems here, and I think you're really on the right track for the monetary piece and the child labor piece and all that. My concern is still with you know, the sexualization of the child and all that. And I'm wondering, and I can give you some time to look at this, but I'll just read the piece, because I did reach out to House Research on this. I'm like, what can we do? And it is just really sticky. But I'm just wondering if you think under the definition of, well, it's chapter 617.292, and it says this: depicts a minor in a manner that is intended to appeal to the prurient interest in seeing a minor engage in sexual conduct. Do you think that that would cover the other aspect of this that we are trying to get at? Maybe it's already in statute and already illegal if a parent is out there trying to put sexualized images of their minor child out on these platforms.
Representative Scott, are you asking Representative Stevenson to yield?
Thank you, Madam Speaker. Yes, I am.
Representative Stephen will yield. Representative Stevenson.
Thank you, Madam Speaker. Thank you, Representative Scott. To answer your question, no, I don't believe that the existing laws, either against child pornography or the statute that you quoted and the other provisions we have around child protection, are sufficient to cover what is happening out there regarding the sexual exploitation of children through this. There's a lot of tightrope walking going on here to people trying to stay on the right side of the line. And this kind of goes to what Representative Niska and I alluded to when he talked about how difficult it is to draw a content line. So one question we had in committee, I think from Representative Meckland, was, you know, couldn't we more narrowly tailor this to try and just get at the objectionable content and not at content creation more broadly? And when you're talking about the First Amendment, anything that tries to splice out, this is the type of content that is acceptable and this is the type of content that is legal, generally falls afoul of the First Amendment. And so you need to take a more content neutral approach in order to survive that First Amendment scrutiny. But to get back to your question, I did speak to people who work in the child protection area, who work on child trafficking, sex trafficking, who talked about how helpful this provision would be to protect children in the 21st century in the way that they are being exploited online. So I think this is actually necessary and that existing law isn't good enough. Representative
Scott.
Thank you, Madam Speaker. Yeah, and I mean, I look at even like one of the other suggestions was to maybe amend the definition of sexual harassment to include something like this. And I think there might be something there too, but I'm gonna vote for the bill today. I think it's a good start, and I think as time goes on, we'll find ways to address the concerns. We'll see how the bill performs legally and that sort of thing. But so much of this is just bad parenting, right? It's just, and it's super hard to always nip that in the bud. But thank you for your efforts, and I'd be happy to work on this in the future. Thank you.
I recognize the member from Chisago, Representative New Brindley.
Thank you, Madam Speaker, and thank you to everyone that's asked questions and offered comments today. It's been helpful, and certainly I appreciate Representative Stevenson. It's probably been a month and a half or 2 months since we first talked about this issue, and certainly shared our horror about the impetus for this legislation. And it is really difficult, and it is a really difficult issue. And I think what we're all trying to get at, right, and this is the sticky wicket, this is the problem we have, is that the problem we all have is this disgusting exploitation of children. That's a problem that every single one of us agrees on, and that's what we want to get at. And frankly, I like and appreciate the provisions in the bill that that minors receive 30% of the income. I think all of that is just fine. I am a little concerned about the expanse of this, of using child labor law as sort of the hook to be able to get it done. And again, I understand the sticky wicket, right? Like, we got to find a way to get at this. And as you indicated, I just said to somebody else over here, the problem we have is the First Amendment and trying to attack content. That's very difficult to do, although I think Representative Scott is on to something, particularly when it comes to children. There are different standards, and so how can we maybe work with those standards? The piece that I'm actually most concerned about is the child labor piece, and that we are now saying that a child under 14, that this is now a working condition. And I think about all the good, wholesome stuff that's out there, right? And that in order to get at this nasty stuff, we have to get at a whole lot of stuff that is actually pretty wholesome. I mean, frankly, when we all have our things, right? When I do my doom scrolling, it's typically families who have gone off grid and live in an RV, and that's how they spend their lives. That tells you where my mind is. But that's a totally different scenario, right? Those are families that have made these really fun choices for how they're going to live their lives that work for them. And could the families choose not to include any of their children under the age of 14 in those videos? Well, sure, they can choose that. But there's also nothing inherently wrong with those kids being in those videos, right? Or to Representative Gilman's example of, you know, I'm a DIY family, and my kids, they work with us all the time. And I think, I don't know, there's nothing objectionable about a 5-year-old, a video of a 5-year-old helping her family, sweep a floor and roll out a rug or whatever it may be. There's nothing inherently wrong or objectionable about that. And yet, the way the bill is crafted now, it also has to sweep in all of that. And that's where I'm really struggling with this. That's where I'm really struggling with it. Again, I think the shared compensation is just and reasonable. Certainly the goal of the bill to get at this really insidious, clearly disgusting exploitation of children is what we really want to do, and hopefully this would do that. Although I also get a little concerned, and Representative Niska brought this up, and you mentioned that for social media, there's typically an age requirement. However, we also don't do age verification. And so it's happening all the time anyway, and absent age verification, that's not going to stop. I do think, just putting it on the record and on my way out the door, I think the state of Utah did something really interesting when they put age verification on adult content, and guess what? Pornhub just left the state because it wasn't worth it to them. And frankly, if you are so interested in sharing your adult content with children, I got no problem with you leaving the state. So it seems like there are things we can and should do. I do have concerns, and again, I recognize, we talked about this, talking about the problem of figuring out what that hook is, right? And I'm just not sure we totally hit the mark with this in now completely prohibiting something that really is not. It's not done with malintent. It's not done to be harmful, nor is it harmful, right? In the vast majority of these kinds of cases that we're talking about. And yet we're also prohibiting that. I think we still miss the mark a little bit on what that hook needs to be and how to protect these children without punishing families that really aren't doing anything wrong. So thank you for the work on this, Representative Stevenson.
I recognize the member from Wright, Representative Hudson.
Thank you, Madam Speaker. Members, we all know that a lot of the time we walk into this chamber knowing exactly how we're going to vote on bills. This is a scenario, this is a bill where the debate is influential. Came in inclined towards voting for it because of the sentiment of what it's trying to accomplish. The more we've talked about it here on the floor, the more convinced I am that it's a bad bill that does not accomplish what it's being sold as trying to accomplish. We hear the stories, the horrific stories of sexual exploitation, the exploitation of children. But then we're presented with language that doesn't actually address that directly at all. Doesn't address it at all. All it does is it says, we're going to set some arbitrary limits and impose some arbitrary compensation. The number we've picked for reasons that I can't make sense is 30%. 30% that as I read this, and you're welcome to correct me if I'm wrong, as I read this is 30% that's going to be divided amongst any number of minors. So Representative Gilman gives the example of a family of 5, presumably 3 children. If those 3 children, as I read this, in total exceed 30% of the content created, then we're going to mandate that those parents set aside 30% of their compensation into a trust fund that will then be split somehow between those kids. And I suppose that's why we're gonna go through the Herculean effort of tracking every minute that each child was in each video for future reference in case they decide to sue their own parents over it, which is a really odd thing to be trying to facilitate and encourage. tension amongst families. And what this bill doesn't seem to take into consideration, just the blanket assumption that any time children are involved in the creation of value with their family, and there are other examples that come to mind. Farming has been raised in chatter over here, chores around the house. How about a lemonade stand on the side of the road? We used to see those. Every once in a while, I still do. That any contribution, any value add that a child makes that benefits the household somehow doesn't benefit them? That we need to make sure, and we're going to put a number on it, 30%. 30% of the compensation that's created as a result of that project is going to be set aside for the kid. Well, why not? Maybe they're responsible personally for 50% of the value added. Maybe it was 15. How do we know? What objective criteria are we utilizing to make that judgment? I mean, the more I look into the details of what this bill does, the more arbitrary it feels, and the more it feels as though what we're actually accomplishing is just making ourselves feel good for having done something in response to problems that aren't directly addressed by this bill. Now, if you'd have brought a bill to the floor today that specifically targeted the exploitative behavior that started off our discussion here tonight or this afternoon, I'd be all for it. And we should do that. We should be targeting and punishing parents who are engaged in the exploitation, the actual objective exploitation of their children. But the idea that we're going to attack that problem through a civil process that provides their kids with the opportunity to sue them years from now when they turn 18, how is that protecting the kids? If they're being exploited, let's stop the exploitation today. And if that's really what we're trying to do, we should be targeting the bad behavior today, not providing a civil mechanism for a child to perhaps realize years later, oh my gosh, I think I might have been exploited. I should sue my parents over it. That seems like a really sloppy methodology for trying to solve the problem that was outlined at the beginning of this presentation. The more I talk about it, the more I'm leaning no, but I'm still open. You can convince me that this bill actually does do its job, and I would welcome that. Thank you.
To the author of the bill, Representative Stevenson.
Thank you, Madam Speaker, and I'll be brief because we have a big agenda and just hope that it's compelling enough to convince Representative Hudson and others. To pick up where Representative Hudson left off, frankly, that's why the bill includes a ban on kids under the age of 14 doing this work, and that is not enforced. When we were talking about the civil right of action, that's with regard to the trust. And there was a conscious decision to not make that something that the Department of Labor or whatever else enforces, but to just say, we're just going to leave that as a civil right of action. Trust that most parents who are doing this are going to do the right thing, set some money aside. For the few who don't, the child has a recourse against their parents. With regard to the ban, that is enforceable by the Attorney General under this bill. And it is just saying it is not acceptable for children under the age of 14 to be engaged in this type of work. The potential for exploitation and long-term harm is just too high. You asked why we can't more narrowly target the specific behavior, and that was the discussion we had earlier, and Representative New Brindley said it. It is the First Amendment, and as wonderful as the First Amendment is and free speech is, it does present a difficulty when trying to get at the harms specifically involved from the phenomena of social media. I have wrestled with that. Representative Robbins has wrestled with that. Representative Bonner, Representative Elkins, we've all been wrestling with how do you protect people while still respecting and complying with the First Amendment. And you have to stay content neutral in order to do that. And so my judgment after thinking about this and looking at this for a long time is that the harm is just too great for those young kids from what we read about in the New York Times and other places. There are things that have really nothing even to do with sexual exploitation that also will make your blood boil and your blood pressure go up. There's some really reprehensible things that people are doing with their children to make money on the internet. It should stop, and that's the approach that the bill takes. So appreciate the good discussion today. Ask for a green vote. Thank you.
There being no further discussion, the clerk will take the roll. The clerk will call the names of the members voting remotely.
Carol.
Okay, here you go.
Carol, yes.
Carol, I. Howard.
Howard, I.
Howard, I. Cagle.
Cagle, aye.
Cagle, I.
The clerk will close the roll. There being 103 yeas and 26 nays, the bill is passed and its title agreed to.